19227FC.
David, I don't stand very on behalf of the defendant.
Okay, hold on one second. All right, this is the date and time set for sentence. You are Demetrius Jenkins. All right, and, Mr. Jenkins, have you had an opportunity to read and review the pre-sentence report?
Yes.
Have you had an opportunity to discuss the pre-sentence report with your attorney? Are you satisfied with your attorney and the advice that he has given you? All right. Mr. Goldstein, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Yes, Your Honor. On the face sheet, it says prior record conviction, 4 felonies. That is not correct. He had 3 felonies that were handled under the HIDA program in 2009 in Wayne County. And although I do agree they do count for guideline purposes, they do not count as convictions. So the face should read 1 prior conviction felony and 2 prior conviction misdemeanor.
All right. And Ms. Weiss?
I have no objection.
All right, so we will mark that each one under felony convictions will read as 1. All right.
Okay, now on page, just a minute, John. Shouldn't have closed the report because I had it written. Well, on page where it talks about family, I believe it's page 12. Under mother's occupation, it lists MDOC and then a number. I'm not sure what that means, but that's not her occupation. She works in the factory. Sir? No, I understand, but it says occupation, and that's not accurate.
All right.
That she works in the factory.
All right. We can move that somewhere else.
Well, it's in the, down below, it indicates that she was on probation in 1999.
Okay.
So that's already there.
We'll strike it from occupation, and you can put that number lower in the body of the report. Okay.
Yeah, I think as far as errors are concerned, that's it. I do want to address the guidelines, but
Yes.
at this point, I'm talking about errors.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
All right, the probation department in this matter has computed the minimum sentencing guidelines to be 135 to 225 months. And you have a dispute, I believe, with OB6, is that correct?
That's correct, Your Honor. I would indicate, first of all, excuse me, there are 2 SIRs, because there are 2 different charges, or 2 different files, and they are identical. So any comments I make have to do with both files.
Thank you.
Your Honor, OB6 should be scored at 25, which in the, I don't remember the exact language of the variable, but it says basically the unpremeditated intent to kill or the causing of creating a situation with a serious risk of serious risk. And I think that defines what happened in this particular case. The court did present, or the prosecutor did present a case talking about that, and as I pointed out to the court, the paragraph that was outlined or that was underscored is talking specifically about a charge of 7401, or I believe it was, or 7402. I'm sorry, 333.7401. And this was not charged in this case. This was charged as an OUIL, I'm sorry, delivery causing death. And so the argument or the ruling in that case, which is, by the way, is an unpublished opinion, the ruling in that case applies to a different charge, not to the charge before the court here. And so I'm still saying that this is not a major. Yes, a delivery can be a major if it's charged that way. But this was a delivery causing death, so death is an element, And therefore, the proper scoring is either 0 or 25. But I would say no more than 25.
Thank you, Ms. Weiss.
Your Honor, based on the plain language of the OV of the statute, 50 points should be assessed when the offender either had premeditated intent to kill, or the killing was committed while committing one of the listed offenses. One of those listed offenses is a major controlled substance offense. The defendant was charged and convicted of delivery of a controlled substance causing death. These deaths resulted as a direct consequence of his delivering those controlled substances, Your Honor, and I would say that 50 points is appropriate for OV6.
Briefly, Your Honor, the case that was presented, I don't know if it came from Ms. Weiss or if it came from the court. The case talks about 50 points specifically when the charge is a delivery, not a delivery causing death. So that language in that case is not applicable to this situation.
OV6, scoring of 50 points is when the offender had premeditated intent to kill, or the killing was committed while committing or attempting to commit arson, criminal sexual conduct in the first or third degree, child abuse in the first degree, a major controlled substance offense, lists some other offenses. In the matter of the people of the state of Michigan versus Darren Mendel Evans, docket number 321909, which is an unpublished Court of Appeals opinion. He was sentenced he was found guilty of 1 count of delivery of a controlled substance causing death and 2 counts of delivery of a controlled substance less than 50 grams. The Court of Appeals addressed this issue. OV6 for Mr. Evans was scored at 50 points. And the court held one of the enumerated crimes listed in OV6 as a major controlled substance offense. MCL 777.36, parents 1, parent A. By statute, a major controlled substance offense is defined to include violation of MCL 333.7401, parents 2, parent A. MCL 761.2, parent A. People be federally 229 Mich. App 511. As noted, MCL 333.7401, parent 2, parent A, prohibits delivery of Schedule 1 or 2 narcotic, and defendant violated this provision by delivering heroin to the victim. CMCL 750.317A, because defendant delivered the heroin that killed the victim, the killing occurred while the defendant committed a major controlled substance offense, and OV6 was thus properly scored in the Evans case at 50 points. In this matter, the defendant was convicted of the delivery of a controlled substance causing death in violation of MCL 750.317A. MCL 761.2, parent A, defines a major controlled substance offense to include delivery of a controlled substance as a violation of the MCL 333.7401, parent 2, parent A, here as in Evans, because defendant delivered a controlled substance that killed the victim, the killing occurred while the defendant committed a major controlled substance offense, and therefore the court finds that OV6 is properly scored at 50 points. Have you preserved your objection? Okay, so is there any other guidelines you wish to score?
No, Your Honor.
All right, I believe we have someone who wishes to speak to them.
I do. I have 2 people, Tina Parrish and Jody Reynolds, who both like to address the court.
So Mr. Jenkins and Mr. Goldstein, do your best. And if you could step up to the podium, please. So Ms. Weiss, could you, someone to adjust the microphone? And then just step right up to the podium. Can you state your name for the record, please?
Tina Parrish.
All right. Do you have something you'd like to tell me?
I'm sorry.
It's okay, take your time.
Just wanted to say that, you took, my son was my everything. I mean, he used to call me every day, and on me every day. Josh was born and he went through a lot of problems and he had a lot of challenges to overcome. We got through all of that. He was a good kid. And not only did he take away my son, I mean, he loves so many people and he's really outgoing and Josh loved everybody, and you have a chance. I don't even know if you have kids, but you have kids. I mean, you took away my son, you know, and I think you should, you know, if you could give him the max, that's what he deserves. You know, my son is dead. He's never coming back. I'll never see him again. I mean, when I first found out, I worked full time. You know, I usually manage places. I couldn't even go to work. I mean, I'm just now getting back to work full time. You know, my hair was falling out in clumps. I couldn't even get out of bed sometimes. I don't talk. But I don't hate you. It is an ugly word. But I want you to, you know, deal with what you did. Not only did you take Josh, you took another great guy, Milton, and it seems like after this happened with these two deaths that you would change, but no, you went out doing the same thing, selling drugs still. You know, that didn't change anything for you. But maybe years in there, maybe that will, who knows? But you took away my son and you can never replace that. Josh was one of a kind. And I miss him every day and I'll never see him again. That's all I have.
Thank you, ma'am. So Ms. Weiss, is there anything you'd like to place on record?
Just, Your Honor, that, I would ask you to follow the recommendation by probation to, based on the guidelines as they were calculated, I don't think it fairly takes into account that 2 people died as a direct result of the defendant's actions, and so I would ask you to follow the recommendation of 25 to life on, to 80 years on one file and a term of life on the other end.
All right, thank you. Mr. Goldstein?
Well, Your Honor, before I begin, I want to make a brief comment, which is more directed toward my client, his family, and to the court also, which is that my client did not plead guilty in this case. He went to trial, which of course he had an absolute right to do. My client, despite the verdict of the jury, still maintains his innocence, which he has an absolute right to do. But I have to address the court today on the sentencing day based upon the fact that the jury did return the verdict. So I'm saying that because I want my client to understand that. Not that I agree with the jury's verdict, but I have to take that as a reality in dealing with the verdict. Also, I generally do not respond or take issue with things that are said by people who give victims impact statements. In this particular case, I do want to make a comment about one thing that was said by Ms. Parrish, where she said that even after this happened, my client continued to deliver drugs. There's no indication of that. My client was on bond.
All right, during the court proceedings, I expect it to be quiet. I understand this is emotional, but we're not going to have an outburst. You'll have to leave the courtroom. Thank you. Mr. Goldstein?
There is no indication, Your Honor, no charges were brought. My client was certainly on the radar of the police in this county based upon this particular charge and based upon the desire of the police to bring charges against Alvin Jackson, who was originally a defendant in this case and was dismissed out. But had my client been involved in any illegal dealings, that would have come to someone's attention. But here we are, a year and almost 5 months later, and there's no indication that my client is engaged in any illegal activity. So I did want to comment that to the court. With regard to my client in this case, Your Honor, two things I think the court really needs to take into consideration. This is not my client's first felony, but he has no prior felonies or prior charges involved in this kind of behavior. In 2009, he was convicted, or I shouldn't say convicted, because it was HIDA. In 2009, there was cases involving the possession of a firearm, and I believe in 2012, in Wayne County, there was also a charge involved in the possession of a firearm. My client has no history of drugs, has no history of violence, no history of any of that kind of behavior. Second of all, and I think of great concern, is that my client certainly didn't intend the death of anyone in this particular case. He bore no ill will toward anyone, and whatever happened, happened, but it wasn't assuming it happened the way it was said by the witnesses. I'm going to phrase it that way. He certainly didn't intend it to cause the result that it caused. This isn't a case of somebody taking a gun and shooting another person, or taking a knife and stabbing someone, where there's a direct correlation between their act and the result. My client certainly, if he did what they say he did, didn't intend the result. So I think the recommendations for life in one file and a term that greatly exceeds the guideline in the other file is totally unjustified. Now, Ms. Weiss did make the comment that she doesn't feel that the guidelines take into consideration the fact that there were two people who died in this situation. They did. I mean, they say very clearly, multiple victims are considered, and in this particular case, they can't be scored because of the nature of the offense. So the guidelines, well, in essence, they took into consideration, and they said it doesn't matter in this particular case. So I'm asking the court, given the fact that my client has no history of violence, no history of drug dealing, that the court sentence my client to the mid-range of the guidelines, and then let the Court of Appeals decide whether the conviction is appropriate or not.
Mr. Jenkins, is there anything you'd like to say on your own behalf?
No, ma'am.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offenses, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. Criteria and the reasons for the sentences are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. It's the sentence of the court that on docket number 18-19226 FC, you will serve 225 months to 80 years with the Michigan Department of Corrections. We'll give you credit for 117 days already served. You will pay restitution in the amount of $11,375.85 to be paid to Jody Reynolds for expenses. And in docket number 18-19227 FC, you will serve 225 months to 80 years with the Michigan Department of Corrections. You will receive credit for 117 days already served. These are, let's see here. These are concurrent with each other. There's a DNA testing fee of $60, $68 state cost on each file, and then $130 crime victim assessment fee on each file, and any supervision fee the parole board would order. While under the jurisdiction of the Michigan Department of Corrections, you must comply with all programming, including substance abuse, job skills, education, and cognitive restructuring.
Letter?
Yep.
The jail credit, because it was adjourned from last week, is 123 days.
Okay, so we will change that to 123 days on each file.
And restitution in 19227 FC, there was a statement submitted by that family for $3,135.50.
All right, and we will order restitution in file number 18-19227 19227FC in the amount of $3,135.50. Obviously, if there's any dispute over that, client's entitled to a hearing on restitution. Now, you do have the right to appeal the sentence. My bailiff's gonna hand down to you a notice of appellate, right to appellate review on each file. Please sign the top copy for my records to show that you received those. The other copies are for your records. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. If you wish to fill that out today,
Can you say that again, please?
I'm sorry, go ahead and sign it and then I'll see it. Now, you do have the right to appeal this sentence. If you wish to appeal the sentence, you would fill out the information on this form and mail it to the address listed on the form within 42 days. I will also allow you, if you wish to fill out the paperwork for the appeal today, you could do that and we will process it today.
Your Honor, this was a trial, so he has an appeal of right
Oh,
as
yes,
to the
he does.
conviction and the sentence.
Yes, he does, I'm sorry. So, all right,
Thank you, Your Honor.
thank you.
Thank you, Judge.
The record should reflect, I received back the notice of right to appellate.